Hello, today we'll talk about this troubling decision of the court to set aside its earlier decision to mandate INEC to register the NDC. Facts of the In the case, we'll talk about the pertinent for determination before the court. We equally talk about the rule of law. We talk about judicial authority and judicial principles. The brief facts of the case. As we all know, on the 26th day of June 2026, sitting in Lokoja, presided over by Justice Issa Dashim, made an order setting aside its earlier decision that he made on the 10th day of December 2025. On that day, the Federal High Court ordered the INEC to register the Nigerian Democratic Party as a political party. Subsequently, the Peace Movement Party applied to set aside that judgment, contending that the logo that was a bone of contention in that judgment belongs to them, that they were not joined and be given the opportunity to be heard. The issue before the court is whether the judgment directing INEC to register the NDC should be set aside on grounds that the PMP, a necessary party claiming ownership of the disputed logo, was not joined. Should that judgment be set aside? We'll look at the rule of law. Let's check section 36 subsection 1. Provided section 36 subsection 1 of the 1999 Constitution as amended provided prima facie that every person's right for a fair hearing in determination of his civil right and obligation should be guaranteed. We check the legal principles too. The doctrine of audi alteram patam, rep issa locutor. Hear from both sides and the facts shall speak for itself. We equally check the court judgment in the case of Kotoye versus the Central Bank of Nigeria and Adegun versus Attorney General of Oyo State, where the Supreme Court held that once a party is denied fair hearing, the proceedings are a nullity, regardless of the outcome. My question here is, to have overruled himself, looking at this provision of the law,